Welcome, welcome. My name is Nancy Hafer. I'm the director of the Resource Center for Family Focused Practice, spearheading the California Center for Excellence for Family Finding and Engagement. Really nice to see all of you. So happy to be doing this webinar today for you. Still see a few people are signing in. We have a full agenda packed for you today. And I just lost being able to see everybody, which I think is intentional, but it just it took me by surprise. All I can see is me on the screen. And I'm really happy that all of you are here. So I'm going to do that there. I removed the spotlight. Sorry, that took me by surprise for a minute, interrupted my flow. I would love to start us off by having you all introduce yourselves in chat. So if you could put your name and your organization, that would be really great. Would be nice to see who here is in the house. Say hi to all of your colleagues across the state. We've got a statewide crowd. There's folks registered here from very Northern California to very Southern California and every place in between. Really good to have so many stakeholders here. We are excited to offer this webinar to review some of the insights the Center for Excellence has learned over the last couple of years in our work. We have put together a really fantastic resource for you all. It's called the Bench and Bar Toolkit. We'll put the link to that in our chat so that you can visit it and see what kind of resources we have for you at your fingertips. And we decided to do this webinar so that we could bring some of that learning live and offer it up to you in this format so that you could also ask some questions and see what kind of answers we can provide around supporting a kin first culture from the bench and bar stakeholders, and how bench and bar can work with child welfare and probation and supporting children and youth in their and being with family and keeping family connection and keeping those relationships really, really robust, alive, and being placed with families. So really glad that you're all here. I am going to offer a very brief introduction for our speakers that we have lined up for you all today, and then we are going to dig in. So let's see, so far we're up to 104 people. That is just fantastic. We're so excited that you all are here. I am going to put in a quick note that today we are going to offer a pretty good amount of time for questions and answers. So please be not jotting down, noting some of the questions that you have. We will have a good amount of time for you to be able to ask some of your unique and distinct questions, so we can really have a good, robust conversation. We have heard in our work the last couple of years that there are a lot of questions. Every county does things slightly differently. So this really is a time to come together and learn from your colleagues about how things are happening in their neck of the woods. I'm going to introduce our presenters today. We have David Myers here, who's going to be our lead moderator. He is both a legal counsel, private attorney, and we are so thrilled that he has been a UC Davis instructor now for many years. I think close to 15 years has been an instructor for UC Davis. We have Judge Roger Chan, the presiding judge of the San Francisco Juvenile Court. We've got Judge Talisha Martin, judge with the San Diego Superior Court, the Juvenile Division. And then we also have Stephanie LaCombra here, who has been with the Judicial Council of California for the last couple of years. I'm really thrilled to have all of them here. And I am going to start us off by asking Stephanie to provide a welcome for us. So thank you, Stephanie. So glad you're here today.
Thank you, Nancy. I'm basically here to provide us with a little bit of a background in the history of the law and some of the stats that we're looking at with regard to kin first culture and placement. So the law has changed a lot in the last 17 years. That may or may not seem like a long time to you, but it is not a long time to change hundreds of years of policies and practices. We could go to the next slide. So starting in the 1800s, the child welfare system was set up to keep children safe from families. It's estimated that 150,000 orphan children in New York were sent on orphan trains out west starting in 1853. and then other states followed suit. So the Children's Bureau was created in 1912 to prevent child abuse and improve foster care and adoption. In 1980, the Adoption Assistance and Child Welfare Act was passed, and in 1997, the Adoption and Safe Families Act was passed. All these federal laws were meant to formalize a process to make stranger foster homes safe and create timelines for parents to reunify. Kinship care became an option in 1980 when family was available. And starting in 2008, federal law changed to require family finding and engagement. And in 2008, the federal law began requiring placing agencies to notify relatives within 30 days of a child coming into foster care. In 2016, California law changed to require family finding and engagement for any child not returned home or placed for adoption. If we can have the next slide. So why is family placement better? Why is a kin first placement better? Here's what we know. Here's what the data has shown us, is that children with a first placement with relatives or extended family members are 3 times as likely to remain in that first placement after 12 months. Children with a first placement with a non-relative are 4 times more likely to have experienced 4 or more placement changes in their first 12 months in foster care. 70% of youth placed with relatives are also with their entire sibling set, compared to only 44% of youth placed with non-relatives. And youth who were placed with a relative at the time that they exit foster care are less likely to re-enter care within 12 months. We go to the next slide, please. So knowing that placing with family leads to better outcomes, where are we now? As of calendar year 2023, only 34% of children were placed with family as their first placement in California. That means 66% of children are placed in stranger care for their first placement. That's more than half of the children in foster care that are not placed with family members. So we should strive to do better. And the question we're trying to answer is how? So at this point, I'd like to pass it to David Myers, our illustrious moderator for the fireside chat with Judge Chan and Judge Martin. And thank you so much.
Okay. Hi, everyone. I have just finished my lunch, so perfect timing. It's so nice to see all the names of all the folks here. And I'm going to ask you all first to drop in the chat. If you could please tell me the reason that you are on this webinar. Our judges have offered their time and expertise to answer your questions today. And so I will be monitoring the chat. And Tracy, thank you for posting that. And Lizzie will get on that in terms of the references for the statistics, and Stephanie will help with that too. And if you could put, again, at any time, just in the chat, why it is that you feel like what you're hoping to get out of this webinar, then my job is to make sure we address that. So I'll be looking at that as we go. But first, we drew some straws before we started, and Judge Martin is going to take our first question. And as I said when we were preparing for this, the more all of you hear our judges talk, the better this webinar will be. And for those of you who don't know, we have 2 of the absolute finest juvenile judges in the state, in the country, anywhere. I'd put these 2 up against anyone. And for those of you who don't know, before they were the best 2 judges out there, they were also incredible dependency child welfare attorneys. So they have a wealth of knowledge to share. And Judge Martin, I'll start with you. What are the key components of a kin-first culture, and how can courts and legal professionals promote this approach in child welfare cases?
Well, Attorney Myers, thank you for that question. Before I dive into it, as I was thinking about this presentation today, I had to ask myself, having been in this field for quite some time as a social worker, as minors counsel, and now as a judicial officer, why are we still talking about this in this way? And what has changed that can improve outcomes for our families as well as our youth to be able to remain connected and to be as a family as they navigate this difficult and complex system at times. And I wanted to just throw out what is different right now. And I think there's a little bit more buy-in than there has been in the past about valuing family and about valuing foundation. I also think that there is funding that is, geared towards supporting kin first culture when we've always been talking about the importance of keeping families connected. I mean, hence with, ICWA, but that applies to all families that are involved with our system that touches juvenile court. So when I think about the key components of kin first culture, I think about a village, that it takes a village, which is what the African proverb states, but to support an overall physical, mental health, and well being of children to thrive in an environment that is one familiar to them, one that is healthy, and also one that is safe. And when we talk about key components of kin first culture, I think about engaging families and also acknowledging families as experts on what is necessary to meet their needs, and also recognizing family as priority. And that's at every phase of the juvenile court process, not just in the beginning, but throughout the life of the case, and supporting permanency within family. So developing a strong community to support the family, as well as a strong community to be a resource for the family. Because when the ultimate goal here is reunification, the expectation is that the court will not always be involved in this process with the family. And we want to be able to set them up or support them, if you will, to be able to continue to thrive and function without all of these professionals being involved in their life. So when we think about things that the court can do or has done, I can tell you that one of our goals here in San Diego has been to try to align our child and family servant systems, meaning our justice partners, including the court, to understand the value of maintaining family relationships and to make sure the policies and procedures promote kin relationships. I also think that social workers, having been one, that they have a lot of responsibility on their plate. And we, part of the village, need to assist them in this process in supporting kin first culture. And one way that we can do that is, as legal professionals, we can help by asking clients, so attorneys, ask clients about names of relatives. So that way information can be provided early on to the social worker to do an investigation or to do family finding or to engage with family about being a support for the youth and family that is touching our system. Also, talk about what supports can be available to family during child and family team meetings. I don't know if statewide, if attorneys have the ability to attend child and family team meetings, but if they do, that's an opportunity for them to be a support and encourage their client to share information about relatives and family members or significant others that would be important for that young person and for the family as a support. And maybe some of that can also be reflected in the case plan. So that way, along the way, we're constantly reminding ourselves that we are always going back to who do we have that can be a support and important for this family to be able to continue to thrive and move forward. Also, as a court, as judges, it's important that we inquire of parents who are before us in the courtroom, as well as young people in an age appropriate manner, as to who family is and what that means for them and important people in their lives. And the last thing I'll say, so we can move on to Judge Chan here, is that we cannot forget focusing on paternity, because oftentimes we miss a valuable opportunity to include paternal family in this process, paternal relatives that may be of support. So it is key that we establish paternity early on in the case, because the value of fathers as well as mothers in the lives of children are extremely important. And with our bench and bar toolkit, it talks a little bit about the legal framework for kin first culture and provides a brief introduction regarding that. And so I'll encourage the attendees to take a look at that at some point when they have time.
Thank you, Judge Martin. So I've been looking at your comments. There's a lot of people complaining and pointing fingers, and I really like that. So Judge Chan, let's start there. What are some of the common barriers and misperceptions, or maybe accurate perceptions? Can you speak to that, please?
Yeah, and I've been watching the comments scrolling by as Judge Martin was speaking. In terms of barriers, and as we think about what prevents a kin first placement early in the case, many of those barriers are eliminated by doing exactly what Judge Martin said, which is approaching this collaboratively, that it is everyone involved has a role to play in identifying family members and important people in the child's life. And so a lot of the barriers, many of the barriers are eliminated through collaboration, and particularly through the child and family team model. Because ideally what we see at the initial hearing or at the detention hearing is that a CFT has already taken place. We've already identified relatives or kin who are available, and the process is in place. Judge Martin talked about, what's changed, why are we having this conversation still today? And, for those of us who've been in the area for decades now, and in addition to the funding moving and driving changes in child welfare policy, there are also shifts in child welfare law. And so a lot of this conversation is really about knowing what the laws are, understanding where they are, and then making them come alive and work in a family's life. I think one big barrier that's not as easy to solve by collaboration is our increased understanding of trauma and multi-generational trauma, and understanding that. So part of the model of the kin first is a shift, I think, that is difficult for people who've been in the field for a long time. But that's understanding that healing from trauma can happen together, and that addressing multi-generational dynamics may be best done through this idea of healing together. And so that's one barrier, I think, is understanding the impact of generational trauma, how that looks to us, especially if we're not trained to recognize the signs of it, in particularly how that may build mistrust from family and kin to working with a county worker or coming to court. And that's another big barrier is how do we engage family members so that they become part of the village, part of the team working on the healing of this family. It's particularly complicated when we have kin and relatives out there who may have immigration issues or language barriers, and they're even more resistant to working with a governmental agency or the courts. And being able to overcome those types of misperceptions of the system itself to make sure that we encourage family to step up and be ready, be willing to go through the assessment process to receive the child into their home. And a lot of that relates to our own sense of understanding and appreciating cultural diversity and our cultural humility and our willingness to listen. The easier barriers to address are more practical. So, for example, really from the initial removal, but certainly at the detention hearing, and then the first report we get from the county worker, there should be information about relative finding. And there's also the new law, or relatively new law, to talk about the harms of removal. And so the barriers, I think, for lawyers, the barriers for social workers are obvious. I mean, the law requires you to gather a lot of information in a really short amount of time and then write it down in a way that everyone can read, and to do all that probably within 72 hours. So we understand the workload barrier on that. And then for the lawyers who are meeting their clients for the first time, being able to get the reports as timely as possible and have time to go over it with your clients. And then kind of what I hear often is just remembering to ask what relatives are out there, because there's so many issues you have to cover at the very beginning, Indian Child Welfare Act, parentage, what are the allegations in the case? What are your rights? There's so many things to go over. And within that, sometimes asking about relatives gets lost in that. For parents counsel, it can be a little tricky because your client's focused on having the child return immediately. And so you have to talk to them in terms of plan B and plan C. And for children's counsel, you're explaining a lot of things to a young person, but just remembering to ask early and often about who is important to the child and who might be available. There's a comment in the chat that I think really hits on point with one of the major barriers, and that's the way in which a delay in placement with family or kin in and of itself becomes the barrier to kin first placement, because the life of a child does not stop. And with every passing day and week and month, the child's becoming established and settling into their environment. And so when there are barriers to either locating, identifying, or approving a relative or kin replacement, in the meantime, the child is adjusting to a new setting. And then that becomes a factor that we all discuss, months later on down the road, on the impact of disrupting the child's stable, loving placement. And we've all heard, we all have these cases, everyone has made the argument from different sides. As judges, we have heard the arguments. And those become really difficult decisions, especially when it's become not just months, but it may become years before, well, maybe not years, but it becomes more than 1 year in which the kin first placement is still at issue. The law has tools that you need to be aware of to expedite the kin first placement for those that are having trouble going through the approval process. I think going back to the idea that it takes a village, I think everyone needs to just encourage relatives to step forward. Other barriers, of course, are when the parents don't want to involve other members of their family or important community members because they're embarrassed or just don't want people in their business, and being able to overcome that barrier and encourage them to think about the plan B and the plan C for the child. So again, some of these barriers I think we can deal with collectively in practical ways, and some of them are just all of our increasing our education and understanding about some of the underlying drivers, and recognizing what we see, and being open and promoting the idea of a kin first placement.
Thank you, Judge Chan. I appreciate that. Before we get to the sort of it's everyone's job in a little bit more detail, just a couple of thoughts. First of all, for those of you who don't know our celebrity guest in the audience, Kevin Campbell, who put in the chat, is really one of the founding fathers, if not the founding fathers of the Fostering Connections Act that was passed federally. He's been a tireless champion, and he taught me a long time ago to always treat relative placements as an emergency, and the removal of children as an emergency. So I'm glad he's here. I've encouraged him to keep dropping wisdom in the chat as he has been. That's why you're seeing him come up, and I'm really glad you're here, Kevin. It's been way too long, and I'm glad that you are still here. Um, and there's always work to be done, so we got to keep going. Um, and also the link to the Bench Bar Toolkit is in the chat. Thank you, Lizzie, for dropping that in there a couple of times. That Bench Bar Toolkit was designed by attorneys, several of whom are on this webinar, and reviewed by our two judges. It is a toolkit for judges and lawyers. So the first section is what is the substantive law with hyperlinks. We'll talk about that a little bit more as we go. But Judge Martin, back to you. Some concrete examples, I think, of to steal a line from our social work colleagues, what's working well?
Thank you for that question, Attorney Myers. One thing that I heard that works well, and it's always been somewhat of a tenet for our juvenile court, um, in spite of the emotions that are involved and the issues that we deal with, is collaboration and really finding a way to be able to come together as professionals and also include the family in the process. I think is what works well. And regarding San Diego, when I thought about this question, I was like, okay, what's working well in our court around this issue of kin first culture? Because it is certainly an issue that has been prevalent, that hasn't always been at the forefront and hasn't always been practiced. And so, one thing that we've done as a specific example is that we convened our justice partners. And we started by doing so through a training countywide to bring our minors council, parents council, our CASAs, county council, social workers, probation, defense counsel, district attorney. We all came together for a countywide training to talk about kin first culture and how that should be priority and what that means within our county, and to discuss policies and procedures and practices that we currently have in place and how that might be a barrier to our success in achieving this goal. And at that county-wide training, we broke out into work groups and we brainstormed, solutions and recommendations. And after we did that part, we just came together as a court with our justice partners and started a monthly work group to develop a plan of action with our Health and Human Services Agency, Child and Family Wellbeing. So that way we could begin to really dig in and just tackle some of the issues that we were confronted with. And as a result of that, there's been some changes in policy. We now have a family finding unit, which we did not have, where we have workers dedicated now to finding family. That was not always the case, but we do have that now. We also have our Child and Family Wellbeing. They just launched their Kin First Accelerator program, which is brand new to our county. So that way we can begin to continue to figure out how do we move this concept forward. So it's not just an idea or a fancy term, but it is actually action as to engaging families. And as I saw in the chat with Mr. Campbell, welcoming families and including families in this process. And when I think about, over the course of the last probably year when we started on this task here, some of the lessons that we've learned is to maintain an open mind, about change and what that may look like, and be flexible with change. Always, just understanding that things are not going to go as we exactly line them out to be, but to be flexible in that and just not, throw it all out the window because it's not going the way that we plan. And I think it's also really important that we stand in the shoes of our partners so we can see things through their lens and understand what their challenges and limitations may be. So we're not coming across as judgmental in this process, but really trying to understand each other's strife, if you will, and figure out a solution for that and bring to the table solutions. So that would be some of the specific examples that I would provide.
Thank you, Judge Martin.
Can I ask Judge Martin a follow-up?
Absolutely.
So, Judge Martin, I have been so impressed by the monthly justice partners and the collaboration that was built in San Diego. How does a jurisdiction, how does a county get buy-in? How do you get all of the right players to the table to establish something like a monthly work group to look at issues like this?
I think one way is that we include everyone who has a key role in this decision-making process, right? Which are the attorneys, which are the social workers and county council and the CASAs who are involved. We brought them all together so that way we can all hear each other out, if you will, about what this means within each of their respective agencies, what this means for the court, and to just hear those grievances first. So that way we can then, figure out, well, how do we move this forward in a solution focused, fashion? What are we going to do about it? Because the law requires it and we need to follow it. And so what are we going to do to help us accomplish that goal? And so that's where each agency went back on their own and internally began to discuss and talk and think about those things. And we just kept coming back to the table. So that way we could continue to process and work out an action plan, if you will. We even brought in judicial counsel to, help us with the technical assistance and whatnot to help talk with us around some of the policies and procedures that have been longstanding and also have been barriers to having youth be placed early on in families, or where we may not have constantly followed through with inquiring about families instead of focusing on once a child is placed, that's it, it's all good. Let's think, broader than that, and continue to inquire, continue to assess, and continue to ask families, what their needs are and who is important and who we might include in this process.
Thank you. So this is where I take some narrator, moderator privilege, and we're going to go off the script a little bit because there are two major themes running through the chat that I really want to hit. The first for Judge Chan would be 309. For those of you who don't know what that means, and Judge Chan I'm going to give him a second to formulate his answer. I will say two things before I ask my specific question. One, you mentioned talking to clients about talking to parents about the apprehension they may be feeling. I always tell my clients, I always ask them, look, if you got a call from your cousin saying, hey, my kids have been removed and would you be willing to help out and take some placement, how would you feel? And 100% of them always say, I would take up that call and I would be there. And I always ask, would you feel judgmental toward your cousin? And they all say no. I'm like, okay, let's pick up the phone. Let's get that done. The other thing I always ask for at detention hearings, if children are not placed with relatives, I ask for an emergency placement hearing. And luckily, the judges that I appear in front of are very open to that. And I ask for it 2 or 3 days out. And that hearing can be vacated if the kids are placed with a relative. That's after I do a little pre-screening to make sure that the relative, of course, would meet the 309 requirements, which is Clet's khaki walkthrough, people. That's all we need. So Judge Chan, your thoughts about 309 emergency placement, and why don't we see this more often?
I think from that's a good question. Why don't the judges see it more often is because somebody has to bring it to our attention. We don't, we may get some information. We'll have information from hearing to hearing in the social worker report. But if someone doesn't, and for judges, then we issue spot and we see that there are barriers or delays to a relative who's requested placement, but has to go through some waivers. So what needs to happen is similar to what you just identified, David, which is if and because as you all know, the time between hearings can be lengthy, even though we're supposed to go fast. It will be weeks, if not months, between hearing dates. And so lawyers need to bring it, or social workers need to bring it back to the court's attention if you need the court's help to make an emergency placement. And I do see that happen in my county. And I honestly couldn't tell you if that was an exception or if that was a common protocol. So I don't know what I don't see is, I think, the answer from the court.
I very much appreciate that. And Judge Martin, there's also been a theme about keeping relative placement. So, and I'm going to ask you to talk for a minute about a lot of social workers will tell relatives, you're not parties, you have no rights, and a lot of lawyers kind of feel like they're just the hired help, these relatives, and they have to do what the social worker says. They have to facilitate the visits. And then, of course, if they can't do that, the child will be removed. Some counties use 387s to do that. Some counties don't. I'm interested in your thoughts about maintaining relative placement. And of course, when children are removed from relatives, how you advise judges and lawyers to handle that issue.
Thank you for that question. With respect to relatives, I think it's important that they feel included in the process. And if they're not quite getting that feeling when they're working with the attorneys or social workers, then it certainly is incumbent upon us as judicial officers to promote that, if you will. So whether we're encouraging that they be present at court and asking questions of them about their care of the child or their interest in being involved with the child. Maybe they can't take them on full time, but they certainly can be available. If they want to take the child on an outing or support a child at a school event or something of that nature, it's really, I just think about it from the sense of, my own family. What would I want, from, my, my aunt, my uncle, my grandmother, my grandfather, how do we incorporate that into this process so that way the children and the parents who are involved feel supported by their family and feel included. We do have the relative family form that can be filled out, relative placement. I think it's the JV 285. I might get the number wrong, but there's a form that can be filled out from relatives to give information to the court. So that way the court can have an understanding from that relative's perspective, as to what's going on with their care of the child. So I think that's important. So it's being inclusive and making the relatives feel like that they are a part of the process and that they're not just there to just care for the child and only do what they're told to do. We want them to be a part of the process. Can you tell me the second part of that question that you asked me about placement?
Yeah, when children are removed from relatives, which is
Mhm.
sometimes necessary, and many
Yeah.
times that's reasonable minds can differ.
Mhm. Yes. Well, I always like to think of it as what is the least alternative disruption that can help keep a child safe. So if there's something going on with the current caregiver, then I think that the first step would be helpful to talk about is, are there any solutions that can be put in place to resolve that? But I can tell you on the flip side of that, sometimes, we hear as a court, and in particular from the parent, that, here we are placing, their child in, this home, and the child is doing worse there than they were with the parent, right? So do we need to look at that as well and see, are we in a space now where maybe the child can be with their parent? I don't know, but it just depends on what the issue is that's coming before the court. And the court, I believe, needs to be able to inquire, to have information coming directly from the caregivers as well as from the counsel involved regarding their understanding of the circumstances for the court to be able to make an informed decision. And I guess to just kind of piggyback on what Judge Chan said, that if we're not aware of what the information is or the issues are, then it's hard for us to be able to figure out a way to address those. And so it's really creating a trauma-informed courtroom environment where folks feel comfortable being able to communicate with the court, as well as feel comfortable being able to communicate with their counsel. And that requires definitely some rapport building and some trust building to get there. And it does take some time to do so. But I think it's something that we have to constantly continue to work on.
I love that answer. And I'm turning back to you, Judge Chan. First, I want to comment on the thread in the chat about attorneys at CFT meetings. Lovely topic, not going there today. But please continue to carry that through on the chat so we can get other people's opinions on it. Judge Chan, I will first invite you, if you have comments about the 387 process or removal from relatives, if you have anything to add to what Judge Martin said, of course, please do. My actual question for you is, what do you do, like consciously, to make your courtroom kin first? And what is your advice? Well, just tell us, because that will be your advice to other judges about this is what I do to make my courtroom consistent with what I'm saying.
Sure. As you can see in the chat, there are a lot of really frustrated San Francisco lawyers. And lawyers, please don't talk to me about your cases in the chat. Let me answer your question, David, and I'm going to circle back to some of this. So, I think from what I can control within the four walls of my courtroom, I think the key is what Kevin said in one of the earlier comments and Judge Martin highlighted, which is being welcoming. And Kevin makes a really good point about it's not just finding, it's also seeing the relative and the kin. And so the ways that I hope that I make my hearings feel welcoming and that relatives feel seen is by first acknowledging that they're there and being able to get input from family members about how things are going and to hear directly if there are any issues that need resolution. It's my practice if a relative requests assessment, my answer almost always, in fact, I think it's always, is the court orders the agency to assess the relative as required by law. I shouldn't have to say that, but I acknowledge that there's a request and I require follow-up. And then I make a note to myself that I ask for follow-up so that at the next hearing, if the child is not with the relative, we can talk about why. Another really important part of all this is what Judge Martin said at the beginning, which is establishing parentage and seeing who the entire family is and also being welcoming to them, especially if there are relatives who may not have met in particularly an infant or a younger child before. And I think the knee-jerk reaction a lot of times is, oh, got to supervise everything. We got to, there's sort of the knee-jerk reaction is to be cautious, if not skeptical. And I think the tone of the courtroom needs to be more in terms of, we're glad you're here. We want to see you be involved. Let's figure out how to do this. Let's include everyone. And through it all is not losing sight of the child, of course, and where the child is and what the child is experiencing, and asking the questions about that. So in the toolkit, one of the recommendations to judges is to ask questions, is to directly interact with relatives that attend hearings. There was an earlier chat about a frustrating experience that a relative had with just finding the court date and not being notified of continuances and all of that. There's so I think what helps on the day of court is when there is a court attendant or a court officer who's going to the waiting areas to see who's present and letting letting the court know who's there so they can be checked in or receive information. And in counties where you don't have that sort of you don't have that person monitoring the hallways, that's how people get lost or get missed, and nobody knows that they're there. So I will ask at the beginning of a hearing to the lawyers, are you expecting anyone else? Is everyone here? And then making sure that we provide an opportunity for those that we're expecting to log into Zoom or we go look for them in the hallway. So being inclusive and thinking about the mechanics of the day of court to make sure that people who are there are seen and heard. And also, I just also wanted to really highlight something for post-permanency cases. For those cases, and however your county handles it, whether it's a dedicated calendar or not, it's really easy to lose sight of what's going on for kids who have been in long-term care, especially when they've had multiple placement changes. And I just think it's really important for the court and for everyone involved to have some sort of bigger idea or vision for what's going to happen with that case. I think especially when you have a heavy caseload, the post-perm cases maybe don't get as much attention as a reunification case. And I think it's really important to focus on those, especially if there's no permanent plan. And to be willing to put everything back on the table, even things that were tried in the past. What I've found is that for a lot of the kids who have been post-permanently planned in long-term care, I just generally teenagers, and I like for them to come to court, and I acknowledge that I know you've had it rough. I read that you've been in a lot of different places in your life. How can I help you? Where do you want to be? Who's important to you? What do you want your life to look like? And especially for crossover youth, the ones who end up with their juvenile justice cases, trying to stop this cycle, this spiraling where you have chronic runaway episodes and whatnot. And so I think it's really important, again, not losing sight of the young person to ask the questions, what's happening? Where would you like to be? Where can you go where I know you'll be safe and you'll stay? And then let me figure out how to get you there. So, judges need to be engaged. They need to set the tone in the courtroom that is welcoming and is curious and is asking questions when if the answers are not being offered.
Yeah, much appreciated. Well said. As always, I never doubted we had the right two people for this webinar. I have a few more things I want to cover. If you have specific questions in the next 10 minutes, drop them in the chat. We'll have time for them. Judge Martin, back to you. I'm going to ask you specifically, in what ways can judges ensure that agencies are exercising due diligence in locating and assessing potential kin placements? And if you could include in that answer a direct address to one of the questions that was asked is, because we often see the one and done mentality. Sure, 15 relatives came forward, but we only read about the one. And then if the one doesn't work out, suddenly there's nobody else. If you could talk about that.
Okay. I can. And I think to answer this question, I think it's important maybe to start with specific examples of what due diligence looks like. And I'd like to say, to sum it up, is leaving no stone unturned. That's how I like to view it. It's following every lead that you have. It's also asking follow-up questions of the person being questioned. So that way you have clarity and that you're making sure that you understand that you've exhausted all opportunity to find someone or learn a name or location. It also requires inquiring at every hearing, not just the first initial hearing, but at every hearing. It's documenting the details about efforts of who was talked to, documenting when they were talked to, documenting what was said when they were talked to, documenting where did this conversation occur, how did this conversation occur. Was it in person? Was it virtual? Was it by email? Was it through phone? I think all of those things are important. As a court, it's important when we're looking at due diligence as well, is considering whether the social worker or probation has inquired of the child in an age appropriate manner about who is important to them, about what they feel is important for them, about their relatives. Also, whether social workers or probation have they obtained information, regarding the location of relatives and what have they done to follow up on that. It also requires reviewing the file, and making sure that if there's any information there that seems, not followed through on, that we are inquiring and asking about that. So those are the to-dos, if you will, to help support effective due diligence so the court can make appropriate findings around that or give further direction to accomplish that. Regarding the requirements of documenting, with the recent passage of AB 2929, this should help because it does require a supplemental report be filed in connection with the status review hearing to include for a youth who does not reside with relatives or kin, continued efforts to locate those relatives or kin that may be able to provide family support or provide placement for that young person. And it also requires the court to determine at those status review hearings if social workers and probation officers have continued to make those efforts. So I think that is one way that holds us all accountable. And I wanted to just briefly mention the California Rule of Court 2, the 5.637D1, which includes an ongoing responsibility of social workers and probation officers to exercise due diligence to engage in family finding until the time the child is placed for permanency for adoption. And so I would encourage again to look at the toolkit, the benchmark toolkit, because there is a judge's tip sheet there that can give guidance. There's an attorney's tip sheet there as well, and a placement tip sheet also for social workers and probation officers to just help give some guidance of things to think about and consider as they're trying to locate family and kin for our youth and family.
Thank you, Judge Martin. I have two more topics to cover that I want to do right now. So I want you all to be thinking about the questions you originally asked. Ask yourself if they have been addressed. If they haven't been addressed, go ahead and you can send me a direct message in the chat and I can put that on the list. But back to you, Judge Chan. There was some buzz from the counties about confidentiality, and specifically, this is not the information sharing webinar. This is not, the 827. This is not the, who can I tell to what webinar. But there is some relevance in regard to what information can relatives receive. What should we, and I mean the collective we, social workers, lawyers, and judges, should be telling relatives? And can you speak a little on that issue?
Well, the statute talks about what relatives must receive in the notification, and that's 319, is it F? That describes the contents of the notification that the social worker must provide. So there's information that the relative must receive from the social worker. In terms of what lawyers talk to the social worker, to the relatives or kin about, I think you need, once you determine from your client which relatives or kin you want to reach out to, you need to call and say, hey, so and so, my client, your nephew, your grandchild, um, needs a place to stay. I think you need to use your judgment on how much information the person needs to know versus violating someone else's confidentiality. But you certainly cannot provide the reports to the relative or kin. But I think one way in which placements tend to um, fall apart is because we also haven't given the caregiver enough information about what the child's needs are. And so, and I think that's within the need to know, like, the child needs, has special medical need and needs to have doctor appointments, or child needs an IEP, the child's been not doing well in school and someone needs to go to the school meetings and, there's information that you would expect somebody who's going to care for the child to know, and because they have to do the things that as a responsible caregiver they need to do. So for the lawyers, they're certainly authorized to reach out and talk to the folks that they're hoping to encourage to receive the child into the home. But the bright line no is you can't provide the actual social worker report. Trying to, there's some questions in there about placement, more questions about placement change, David. And in addition to the 387, I mean, going back to one of the purposes of the toolkit, and the reason why we encourage all of you to look at it is because the people who worked on it organized all of the relevant statutes and rules on this. And there are already laws regarding notification for placement change. So I really do encourage everyone here to take a look at the toolkit. It's organized in a very easy to follow way that is actually a toolkit. So going, Judge Martin are telling you, use the role of the court is to make sure the laws are being followed, and you as advocates and as social workers, the toolkit tells you what all the laws are. If there's a problem, bring it back to the court's attention. If you're not getting your required notifications on placement change, there are the young person has rights, and there are certain statutory mandates for how things should work. So that's one of the reasons why the toolkit is out there, because so much of the value system of the kin first approach and culture is embedded in statute. And it's up to all of us to use it and bring it to life.
Thank you, Judge Chan. Our next question is for both of you. If you want to weigh in, I'm going to ask Judge Martin first. And that it was a fascinating one. And it came from one of our data people. And it was the question was, how can data and statistics make more of an impact in CWS? My question might be, can data and statistics make more of an impact, both within the agency and, of course, in your courtroom? I'm interested in both of your thoughts about data, because, as lawyers, we sort of have this learned helplessness over time where we're in front of the same judge every day. We know what they're going to do. We know what they're not going to do. We see the same social workers, the same information every day. We know what's going to fly. We know what's not going to fly. We very rarely see data. We very rarely see reports with data. We very rarely take evidence with data. So it was so fascinating that I thought, let's go outside the box a little and get both of your thoughts on this.
Well, what I would like to say to that question about data is that I think it's extremely important because it allows an opportunity, one, for an issue to bubble up if you will, and to give an opportunity to reassess and think outside of the box on how to address it. And so when I think about data, I think about how data has informed so many things in our system, like psychotropic medication, right? And how we improve in addressing that issue. I think about data with respect to kin first culture and how the statistics show, which Stephanie started out in the beginning, 34% of children are not, I believe it was they are placed with kin, and the remainder are not. Over half of kids in our care are not placed with kin. I mean, those statistics are important because we have to stop and think and ask ourselves, then what are we doing that's not addressing this issue? What can we do differently to get it right? And so I think data is critical because it's the driving force of how do we better improve our outcomes. And so even though I'm not a statistics person, I do like to look at data because that helps to inform me as a judicial officer of just things that I should be thinking about when a family is before me. It may not a specific statistic in and of itself may not be the reason that I'm making a decision, but it gives me insight, to think about the issues that maybe this family is facing or that the attorneys may be facing with respect to representing the clients that they serve, or that the agency may be facing in providing the services to the client. So I think data is key.
I love data. And one of the outcomes of the Kin First program has been a collection of a lot of really valuable data, in addition to the child welfare data available on the public Berkeley website and maybe in your own counties. I operate on two levels. I have the cases, individual cases in front of me in the courtroom, but as a juvenile presiding judge, I get to look at the aggregate data, and I get to ask my child welfare director, why are our rates of relative placement, well below state average? Why, I get to ask questions about reentry rates. And it does help to frame the policy discussion when we're not talking about anecdotal cases or war stories, or, I heard, this happened in court today, but to look at the aggregate data to see our trends and to see whether or not the policies that our county has put into place are accomplishing the goals that we hope for. And if not, to be able to ask questions, why not? What's happening? What's driving this number? So I really love the data that's been collected, and there's a lot related to child welfare that lives in different places, but it's a really useful way of framing policy-wide discussions. There was a question in the chat about how do you engage your judge, especially in a busy county. Using the data is one way to engage your juvenile presiding judge.
Yeah, that's where I was going next, because the two of you can't be in all 58 counties. And there are some judges that don't have an interest. And then there are some judges that do have an interest, but not the time or the bandwidth necessarily. So what is your advice to those on this webinar in terms of how to get to where we all want to be?
Well, I guess one thing I will say, and I was just thinking, I say this a lot to young people and families that are in front of me, is, that sometimes it seems like there's no hope or no light at the end of this tunnel, but to not, accept that, right? We shouldn't accept that. We need to figure out how do we move the needle forward, if you will. And, counties are smaller than some of the larger counties that we are currently in, myself and Judge Chan, but it's really getting creative with this. And so maybe reaching out to the judicial resources and technical assistance attorney for the court to do that, to help facilitate meetings or trainings, or to discuss strategies on issues that have been bubbling up to help provide some guidance and focus. But I guess my ultimate statement is to not give up, that we have to continue to figure out how do we resolve this. And it's challenging when there's lack of funding, there's shortage of staff, there's not adequate services. All of that is, negative, negative, negative. But what can we do with what we have to figure out how do we best utilize that for the purpose that we're trying to accomplish? And it is not easy. I'm just going to keep it real on that. And you all know that, that are on this webinar, that it is not easy, but it is that drive and that will to continue to figure out how to, just like we do with families and trying to understand their core, we continue to peel that onion back layer by layer to figure out how do we get to the goal that we're trying to accomplish. So that would be my input.
Judge Chan, thoughts about your colleagues and how to bring them to this discussion?
You mean other judges in throughout the state?
Yes.
Well, there is a lot of statewide judicial education, especially in dependency. And every judge in every county in California assigned to dependency is required to go through a week-long primary assignment training, as well as to maintain ongoing educational requirements. And then we have other statewide judicial training. And the California judicial education programs are excellent. They're really well done, and the trainers are judges who really get it. And I'm Judge Martin, and I'm not even talking about Judge Martin or myself. There are other trainers from around the state, and so this is part of the curriculum. I think I just to echo what Judge Martin was saying, in addition to not giving up and being persistent, ultimately, each of you have a client to represent, and it's one case at a time, one child at a time, one family at a time. And ultimately, what we all have to do is make sure we get the best outcome for that child and that family, one case at a time. And that's where, in addition to thinking about the larger policy issues, the work needs to be done. Because as much as I love the data and statistics, ultimately what's most meaningful is that the well-being of the child, and that we've done right by that particular young person. So that's where we, as judges, we need the information, help us to understand who the relative or kin person is, help us to understand how the court can help to break down any barriers to making the kin first placement, and we can make decisions one case at a time.
Yeah, fantastic. And just a shout out to Stephanie for putting that in the chat. She's been a rock star all day. Mary Michael, if you're on this webinar, give her a big raise. She deserves it. She's been incredible. And so the question that I posted in the chat was for you, Judge Martin, just now. Follow up to what you said about extra steps that social workers or attorneys need to take to extend an invite to a relative to extend a hearing. And then a question, are there some hearings that they cannot attend?
Well, there's always opportunity for an objection for someone to be in the courtroom, which the court has to decide whether or not that objection should be honored. But with respect to juvenile dependency, I'm primarily in juvenile justice. I do hear juvenile dependency matters, and that was my practice. As far as hearings that relatives cannot attend, if there's I would say it would depend. It would depend on if there's an issue or a reason that that relative should not be involved or a part of the court hearing. So I would need to know what that reason was before I would blanket say, no, a relative cannot attend. And right now, at the top of my head, when I think about our dependency proceedings and process, I can't think of a hearing off the top of my head at the moment that a relative who is providing care to a youth or one who is interested in providing care, why they wouldn't be attending. so that way the court can inquire of what their interests are and what their abilities are and what they might need to be able to help be able to support having that young person in their care. So I guess I would have to know what the situation is for a relative not attending and what the reason is to make that call.
Yeah, I think that's spot on, short of a Marsden hearing.
Yeah.
You know, if
Yeah.
and that's but you said the magic words though, not just the caregivers who have a statutory right to attend, but the prospective caregivers, if they're interested, unless they've been screened out because of some unwaivable history and they are disruptive, etc. We've seen those relatives before, but if they are viable potential options, they should be in the courtroom. They really should. And if they're not, there's a problem there. So Judge Chan, I actually object to the form of this question. But I think you understand why. I'm going to ask you as a great question in the chat. How do you get around a parent that doesn't want their relatives involved? And obviously, I know you're going to go to 361.3, but please feel free to speak on this one.
I think the question is probably more practical, right? So, I mean, because we know that a parent does not have absolute veto power over a relative or kin first placement. So, and in most cases, the parent is not the only person who knows who the relatives are. And so, um, we should still do our family finding based on what we can, even if the parent is not assisting. And if there is a someone interested, they should still be assessed. And we can note a parent's objection to the placement, but it doesn't mean that it shouldn't be looked at. There are cases where you have a nonverbal child and father, usually the father not identified, and a mother who does not want to provide any information. There are some really amazing family finding tools out there that, based on information you have, I think it's like the internet searches and whatnot, that can take place. It's a little bit more, takes a little bit more time, but in those cases where this one parent is the only sole gatekeeper of who the other relatives are, we just have to use whatever other tools are available to try to research information. But I think it's only in those situations where there's a single parent gatekeeper that we don't have a way to really do better or do additional family finding.
And if I could just add to that, because as Judge Chan was talking, I think about all those moments when this actually does occur in court. I think this is one place. There's many, but this is one place where transparency I think is really important, and also in communicating with parents in the courtroom, to really be able to explain, what it means if they're not willing to share information, so that way they see it through all lens and not just maybe the one that they're focused on at the moment, which is I expect that my child's going to be back with me. And so I'm not trying to provide all this information, but to really just be open to discuss, these are the potential outcomes here. This is our goal, but we need your help in this process, and really be able to engage parents in that manner in hopes of, helping them feel a little bit more comfortable in sharing information for support, not just for their child, but maybe for them too, from family. So I think that's important as well.
Can I just add one more thing on? I also think there there are times where the parent has very legitimate reasons not to involve certain family members, and we have to listen and appreciate that too.
Absolutely. That's typically the response is, hey, I'm not opposed, or I am opposed to this relative. The right response from everybody involved, especially the lawyers and social workers, needs to be, tell me more. Tell me more. because that's where you're going to get to the bottom of. There's the rule of the 5 whys, right? If you ask why 5 times, you'll finally get to the real reason. I really want to encourage that as well. So there's some time for more questions. Please put them in the chat. We'll get there. As we wrap up, I'm going to ask Judge Chan to start with the benchmark toolkit and to talk about that. And then Judge Martin, your comments on the benchmark toolkit, feel free to jump right in. And then after you both are finished with that, I'll start again with Judge Chan for final thoughts. And then Judge Martin, you can close us out with final thoughts of your own. And we are going to see the benchmark toolkit. That's the homepage up there. And hopefully you guys can see that. Judge Chan, the floor is yours.
You know, I think I said what I wanted to say about why the toolkit can be helpful in your practice, whatever your role is. So I don't have much more to say about it other than to express appreciation to those who worked on it and gathered a lot of information, including you, David. You did a lion's share of the work.
Thank you. That's very kind. And Judge Martin, thoughts?
Yes, my thoughts are look at it. I'm encouraging you to look at it because it has the law listed there, it has tips listed there, it has some research listed there. I mean, just when I was reviewing it for the purpose of this presentation, there was an article there that stood out to me about 7 ways that you can engage in kin first culture in the courtroom or something along those lines. And I was like, this is, things that we need to remind ourselves of, especially when, we are always the same judge, if you will, with the same counsel, in the same courtroom all the time. We also need to be refreshed, so take a look at the quick tips, and see if there's anything there that maybe you're not doing that you can now do. Or if there's things that you might think might be helpful to add, so that way we can continue to improve upon, the goal here, which is to include families as priority in this process.
Fantastic. I believe, thank you, Diane. I want to give Stephanie an opportunity to come back on. She's going to emphasize something that has already been said, but needs to be said again because it's such a good resource. So Stephanie, if you can unmute and come on back on, and then I'm going to turn to our judges for their final thoughts and takeaways. And before any of you log off, though, I think evals may be coming. And so we are offering MCLE and BBS in credit. So checking on that right now. So go ahead, Lizzie, and launch the evals so that you all get credit for this. So Stephanie, then Judge Chan, then Judge Martin. And if you have further questions, send me a direct message in the chat. We'll talk that way.
Thank you so much, David. I just wanted to reiterate especially to the judicial officers on this call, please feel free to reach out to your JURTA attorney. We are happy to provide whatever resources we can to support you in trying to tackle this issue of moving toward a kin first culture. And as part of that, we're also happy to help arrange for kin first trainings in your county to try and help gather the relevant stakeholders together and really start identifying what barriers your county in particular is facing and how to overcome those barriers. So we stand ready to help you out. We just need to know if you want our help. Thanks so much.
Thanks, Stephanie. Judge Chan?
I got distracted, David, because I was reading the poll and the chat at the same time.
So was I.
Yes.
Some final thoughts. Rick, I'll answer your question in the chat.
Yeah, I just want to go back to how we began this presentation, which is that not only has I think everyone has always intuitively, or reflexively said, yes, let's look at relative preference, relative placement first, but over the last 20 years, not only has the policy and the knowledge has changed, but also the law has changed. And I think really the importance of the toolkit is so that everyone knows what the law is. That this presentation isn't simply about convincing everyone about the change in policy. The fact of the matter is, it's the law, and we want for everyone on all sides to know what it is, so that the law can accomplish its intended purpose, which is the best outcomes possible for young people. And Kevin had a comment in the chat about how rights are not autonomous from family, and that's so important, and that's sort of the crux of what we're trying to do by introducing the toolkit, is to ensure that we are ultimately doing right by the young people and the families that are coming to court. So please take a look at the toolkit.
All right. Well, my final thoughts are, first, I just want to thank everyone for being present today. Sometimes, we may be talking to the choir, if you will, but I say that's okay because as the choir, then it's our responsibility to go out and sing, to go out and, inform and educate and, motivate and empower and encourage others to see things, the way that the law is requiring it to be seen, and also to be of support to get through the challenges and barriers and struggles that often and will constantly pop up in this area of practice. And so I just want to encourage you to do that. And again, thanks for all of your comments. It's a learning process for us too, as we even do this presentation, of things that we continue to think about, that we can continue to bring back to our colleagues or to our justice partners. So thank you.
That's the perfect place to stop. Lawyers are probably wondering about logistics. Lizzie, if you want to drop something in the chat in terms of certificate of attendance, MCLE certificates or BBS certificates, or maybe just an email in the chat so that they can follow up with you to get the credit that they deserve. That's all the housekeeping I have. Thank you all so much for the kind comments. All credit to our judges. They sit on the advisory board too, and the suggestions and the logic process behind what you see, basically everything good, credit goes to them. These two are just tireless advocates, as they were as attorneys, and now they are for families in their role on the bench. And I miss them both because I don't get to work with them nearly as often as I but I am so proud to be able to continue to work with them. We can stay on for a few more minutes if there are questions. And I think Judge Chan, Judge Martin, I know you have calendars, so I can stay on for a few minutes if there are questions. Stephanie, I think you can as well. And Lizzie, if you are able to get on, I know you've been a little sick, so if you could stick around though for a few minutes, happy to have some one-on-one time. And for the rest of you, thank you so much. And this will be recorded and posted on the UCD website. So thank you again, everybody.